Hi, I'm Tom Spiegel from the Spiegel Law Firm, where we represent people who've been wrongfully fired or afraid that they might be. Today, I want to talk to you about 4 mistakes that employees sometimes make when they are quitting a job. And in today's environment, where fortunately there are plentiful jobs for many positions, employees are able to leave jobs to move to new ones, which is fantastic. But there are some legal pitfalls that you should be aware of. One is restrictive covenants, and that's what we call non-competes or non-solicitations. Was there something in your initial contract? Was there something in the employee handbook? Was there something that you signed that restricts you from working for a competitor within a certain radius? Similarly, is there a restriction against who you can solicit business from? Is there a non-solicitation against soliciting the current businesses, your soon-to-be former businesses, clients? What about if you're going to try to take employees with you for your new adventure? Let's say you're starting a new company. Those things can all be cabined by restrictive covenants, and a lot of times people forget about these, right? Like particularly if you've been at a job for a number of years, you may have signed all kinds of paperwork at the beginning when things were great, and you no longer even remember whether or not you have a non-compete. HR can give that to you, but you can also go through your own files and see if that's there. If it is, it's something you might want to consult with an attorney about, because restrictive covenants can be complicated. They're governed by state law, so it depends on which state you're in as to how they might affect you. And some of them, frankly, are just not enforceable or not very good. And so you might be able to a company that tried to enforce it, if you have counsel, or get legal advice and do it on your own, say, look, this is not I don't think this is an enforceable contract, contract. So I'm not going to do what you're asking. I'm going to take this other job. But you should know what the risks are, because it can be, if you do violate them, it can be very expensive litigation and can result in penalties. The second thing is, what about contracts, right? Now, for most of you watching this, you are an at-will employee. You probably don't have a contract. The exceptions are for a higher level position. So if you're a CFO, CEO, certainly professionals, like if you're a doctor and a member of a medical practice, but you're not a partner there, you very well may have a contract with your employer that is probably enforceable. So it can have all kinds of things, like notice provisions that you have to give, restrictions on what you can do with existing clients. Again, it may include a non-compete within that, but you want to be aware of that before you walk away from the job, because the last thing you want is for them to be arguing that, hey, you've breached this contract and now we're going to take you to court. The third one is company property. I think we all understand if you've got a computer or a cell phone, right, you can't keep that. You got to give it back. I mean, most employers are going to help you facilitate that and give you the envelope to send it back in. Don't do what I had a client one time do and put the company cell phone under your car tire and run over it because you're angry. That can get you in hot water. But one thing that some people don't realize is that company property can include intangible items like sales lists, a list of potential contacts, some intellectual property that the company might have. There can be real penalties if you take these improperly. And again, the last thing you want is trying to start a new venture in your life and your former boss is coming after you and saying, hey, you stole our sales list and now we want to take you to court. So it can be very tricky. You just want to be careful about company property and thinking about that broadly. Again, these are all things, you can sit down with a lawyer for an hour, he or she could help walk you through that. The fourth thing is if you think you have a discrimination claim or some kind of claim against the company, you may want to think about the timing of when you quit. If you have a claim against the company, or you think you do, and by that I mean they discriminated against you, they've retaliated against you, whatever it may be. If you quit, there is the possibility that a court could determine that your lost wages have been cut off because you left voluntarily. Well, what are lost wages? Those are the wages that apply in a legal case from the time you've been fired or demoted, your salary's been affected, until you get a new job or replace that salary. And those can be one of the biggest measures of damages in an employment case. And if you leave a job, court finds you leave it voluntarily, court may say, well, you're not entitled to get back wages, which could really affect the value of your claim. Now, of course, if it's an abusive environment, unsafe, those are all things that may be worth quitting. And there is the concept called constructive discharge, which basically is like, even if the company didn't fire you, they basically fired you by the way that they forced you to quit, by the way that they acted. So again, if it's unsafe, terrible harassment, quitting may not cut off those lost wages, but it's something you want to be aware of when you're thinking about leaving that job and starting a new one. Good news for you that you're looking for a new job and that there are brighter days on the horizon, but do be aware of those 4 things before you pull the trigger and leave.